It's 11:30 p.m. on a Friday. You are driving home. You see the blue and red lights flash in your rearview mirror. Your stomach drops. You pull over. You know you had 2 beers at dinner 3 hours ago. You feel fine. You aren't drunk, but panic sets in. The officer walks up to your window, flashlight in your eyes. He asks the question that thousands of people face every single weekend. Have you had anything to drink tonight? And then, the follow-up. I'm going to need you to step out and blow into this for me. Do you do it? If you say no, do you go to jail immediately? If you say yes, do you convict yourself? Most people think the answer is a simple yes or no. Most people are wrong. And getting this wrong can cost you your license, your job, and your freedom. I am going to walk you through the legal reality of refusing a breathalyzer, not the rumors you heard from a friend, the actual law. We are going to look at the difference between the roadside test and the station test. We will look at the Supreme Court case, Birchfield versus North Dakota, and we are going to talk about what happens to your driver's license the second you say, I refuse. This is not legal advice. I am not your lawyer. This is a deep dive into the mechanics of your constitutional rights. Let's meet Julian. Julian is a 28-year-old marketing manager. He's never been arrested. He's a good guy. Tonight, Julian is the character in our story. And in the next 20 minutes, Julian is going to make 3 critical decisions. Let's see if he, and you, make the right ones. The officer is standing at Julian's window. Julian rolls it down. The officer smells chewing gum, and he claims a faint odor of an alcoholic beverage. This is the first legal term you need to know. Reasonable suspicion. To pull Julian over, the officer only needed reasonable suspicion that a crime or traffic infraction was occurring. A broken taillight, swerving over the yellow line. That is enough for the stop. But to extend the stop into a DUI investigation, the officer needs more. He needs to build a bridge from traffic stop to DUI investigation. The smell of alcohol, the bloodshot eyes, the fumbling fingers. These are the bricks in that bridge. The officer asks Julian to step out of the car. Julian complies. This is a lawful order. Pennsylvania versus Mims established that an officer can order a driver out of the vehicle for safety. Julian stands on the side of the road. Cars are whizzing by. It's loud. It's intimidating. The officer says, Julian, I just want to make sure you're safe to drive. I'm going to check your eyes and have you walk a straight line, okay? This is decision point number 1, the field sobriety tests, the horizontal gaze nystagmus, the walk and turn, the one-leg stand. Here's what most people do not know. In almost every jurisdiction in the United States, these roadside gymnastic tests are 100% voluntary. They are not mandatory. They are designed to gather evidence of impairment. They are designed to be difficult. If Julian agrees to these tests, he is giving the officer evidence. If he wobbles, evidence. If he starts too soon, evidence. If he asks a question, evidence of confusion. A lawyer might tell Julian to politely decline these tests. Officer, I am not comfortable performing these tests. But Julian is nervous. He thinks if he cooperates, the officer will let him go. So he does the tests, and because he's nervous and the lights are bright, he steps off the line once. Now the officer has more bricks for his bridge. The officer pulls out a small handheld device. It looks like a walkie-talkie with a plastic tube on top. Julian, I need you to blow into this. It's just a quick check. This is decision point number 2, and this is where the confusion destroys people. This little device is called a PBT, preliminary breath test, or sometimes a PAS, preliminary alcohol screening. It is not the evidence that will be used in court to convict you of being over .08. It is an investigative tool. It is used to establish probable cause for an arrest. Probable cause is a higher standard than reasonable suspicion. It means there is a fair probability that a crime has been committed. If Julian blows a .09 on this little handheld machine, the officer has probable cause to arrest him. So, does Julian have to blow? In many states, the answer is no. The PBT is often voluntary. However, in some states, refusing the PBT is a civil traffic infraction. It might carry a fine, but it is usually not a crime in itself. But here's the catch, and it is a big one. If Julian refuses the PBT, the officer is forced to make a decision based only on what he has seen so far. The smell, the eyes, the wobble on the line. If the officer feels he already has probable cause, he's going to arrest him anyway. If Julian refuses the PBT, he denies the officer that specific number. He denies the officer the chemical confirmation at the roadside. Julian, thinking he has to comply, blows. The machine beeps. It registers .09. Julian is handcuffed. He is placed in the back of the cruiser. He is under arrest. Now the game changes completely. We are moving from the investigation phase to the evidentiary phase. Julian is driven to the police station, or maybe to a Batmobile, a mobile DUI processing van. He is taken into a room with a large machine sitting on a desk. It is not the little handheld PBT. This is the evidentiary breath test, usually an intoxilizer or a data master. This machine is the judge, jury, and executioner of your driver's license. The officer sits Julian down and reads him a form. This form is usually called the implied consent warning. It sounds like legal gibberish, but listen closely to what it says. You have been arrested for driving under the influence. I am requesting that you submit to a chemical test of your breath. If you refuse, your license will be suspended for 1 year. Your refusal may be used against you in court. This is decision point number 3, the big one. This is where implied consent laws kick in. When Julian got his driver's license at age 16, he signed a piece of paper. He probably didn't read it. That paper was a contract with the state. It said, I accept the privilege of driving on these roads. In exchange, I promise that if I ever lawfully arrested for DUI, I will give a sample of my breath or blood. That is implied consent. You already said yes years ago. Now the officer is calling in that debt. So can Julian refuse? Physically, yes, he can keep his mouth shut. The officer is not going to pry his jaw open for a breath test. Legally, he has the power to refuse, but he does not have the right to refuse without consequence. Let's break down the consequences of refusing the station breathalyzer. Consequence 1, the administrative license suspension. This is separate from the criminal court. This happens through the DMV or the Department of Transportation. If Julian blows and fails, blows over .08, his license might be suspended for 30 days or 90 days. He might get a restricted permit to drive to work. But if he refuses, the suspension is usually automatic. It is usually much longer, often 1 full year. And in many states, it's a hard suspension. No driving to work, no driving to the grocery store. No hardship permit. The state punishes refusal harder than the failure. They want you to blow. Consequence 2, the criminal evidence. Julian might think, if I don't blow, they have no proof. Wrong. They have the officer's testimony. He smelled like alcohol, he slurred his speech, he wobbled on the line, and now they have the refusal itself. In court, the prosecutor will stand up and say to the jury, Ladies and gentlemen, why would Julian refuse the test if he was sober? An innocent man would want to prove he was innocent. He refused because he knew he would fail. This is called consciousness of guilt. In most states, the jury is allowed to hear that you refused and draw a negative inference from it. Consequence 3, the criminalization of refusal. This is where it gets scary. In some states, refusing the test is actually a separate crime. You could beat the DUI charge because there isn't enough proof you were drunk, but still be convicted of the crime of refusal. This brings us to the Supreme Court. In 2016, the Supreme Court decided a landmark case called Birchfield versus North Dakota. They had to decide, does the Fourth Amendment allow the police to demand a breath test without a warrant? The Fourth Amendment protects us against unreasonable searches and seizures. Usually, for a search, police need a warrant from a judge. But the Supreme Court looked at breath tests. They said, blowing into a tube is not very invasive, it's not painful, it doesn't invade your body deeply, it's just air. They balanced that against the state's need to stop drunk driving. The court ruled, police do not need a warrant for a breath test after a lawful arrest. It is a search incident to arrest. Therefore, states are allowed to make it a crime to refuse a breath test. However, the court drew a line in the sand. What about blood tests? Blood tests involve a needle. They involve piercing the skin. They take a part of your body that can be DNA tested. The court said, that is too far. For a blood test, the police generally do need a warrant, and you generally cannot be criminally charged just for refusing a warrantless blood test. But back to Julian. He is sitting in front of the breath machine. If he refuses, he loses his license for a year. The prosecutor uses the refusal against him, and he might face a separate crime. If he blows, he provides the specific number, .09, that proves he is guilty per se. Per se means the number itself is the crime. Driving with over .08 is illegal, even if you are driving perfectly. Julian looks at the machine. He looks at the officer. He decides to refuse. I'm not blowing, he says. The officer nods. He marks refused on the form. He takes Julian's license and informs him it is now suspended. But the night isn't over, because the police have one more tool, the warrant. Just because Julian refused the breath test doesn't mean the police give up. In many jurisdictions, especially on no refusal weekends, the officer will simply pick up the phone. He calls a judge. He explains the probable cause: smell of alcohol, failed field sobriety tests, refused breath. The judge grants an electronic warrant. The officer shows Julian the warrant. Julian, I have a court order for your blood. You are going to the hospital. At this point, Julian has no choice. If he physically resists the blood drawn now, he is committing a serious crime, obstruction of justice, or resisting arrest. They take him to the hospital. They strap him down if necessary. They take the blood. The blood comes back at .085. Now, look at Julian's situation. He has the DUI charge, backed by the blood evidence. He has the license suspension for refusing the breath test. He has the prosecutor arguing he refused because he was guilty. He got the worst of all worlds. This is the trap of refusal. Refusal is a high-stakes gamble. It might work if the officer is too lazy to get a warrant. It might work if the prosecutor's case is weak, but the system is designed to punish refusal. Let's summarize what we have learned so you have clear takeaways. Takeaway number 1. Know the difference between the PBT and the evidentiary test. The little handheld device at the roadside is usually for investigation. The big machine at the station is for evidence. Takeaway number 2. Field sobriety tests are voluntary in most places. You can politely decline them. This prevents the officer from gathering video evidence of you stumbling. Takeaway number 3. Implied consent is real. When you refuse the station test, you are triggering immediate administrative penalties against your license. Takeaway number 4. The Supreme Court says breath tests do not require a warrant. You have less privacy protection for your blood than your breath. Takeaway number 5, refusing doesn't guarantee a lack of evidence. Warrants for blood are faster and easier than ever before. So what should Julian have done? There is no single answer that fits every case, but many defense attorneys would say, decline the roadside exercises politely. Decline the roadside PBT if the law in your state allows it. But once you are arrested and at the station, realize that refusing the big machine carries an automatic penalty that is often swift and severe. Knowledge is your best defense. The goal is not to get away with drunk driving. The goal is to not drive drunk in the first place. But if you find yourself in those blue and red lights, knowing the difference between a request and a command and a choice and a trap can change your life. Drive safe, know your rights, and stay educated.